Do undocumented foreign workers in South Korea have labor rights guaranteed? If a foreigner in South Korea violates the Immigration Act and becomes an undocumented resident, can they still be entitled to labor rights? To answer the question, yes, they can get these rights. Let's explore this in more detail through an actual case. What are the 3 labor rights in South Korea? South Korean Constitution states like this. It specifies 3 rights of employees. In a capitalist society, employees usually don't own the means of production and are often in a relatively economically disadvantaged position. As the Constitution guarantees labor rights, workers can still be assured of their rights even though they are relatively vulnerable. The Constitutional Court of South Korea has also made decisions in line with this principle. The court has stated that the 3 labor rights are intended to enable employees who are in a relatively weaker position compared to employers to have an equal standing with them. The right to association ensures that employees have the right to autonomously form associations. The right to collective bargaining is the right of employees to negotiate with employers as a group. In other words, employees can negotiate with employers or employer organizations from the perspective of the union, not as individuals. If an employer unfairly refuses collective bargaining, it can be considered an unfair labor practice, and sanctions can be imposed. The right to collective action is the right for employees to engage in collective actions when conflicts arise between labor unions and employers. Employees can conduct labor dispute actions using various methods, including passive actions like refusing or stopping work. They can even use more active means to disrupt work. But it's important to note that if these actions go too far, they may not be recognized as legally protected forms of labor dispute actions. So, do undocumented workers in South Korea also have the labor rights mentioned above, even if they are in an illegal sojourn status? As explained earlier, yes they do. Let's take a look at the actual case. Some foreign workers in South Korea formed a labor association and submitted a union establishment registration to a regional labor office. But the labor office requested that they provide additional documents as they found the submitted paperwork to be incomplete. The workers partially complied with the request for supplements. Then the labor office rejected the registration. The reason for the rejection was that the workers did not properly meet the requirements, in addition to the fact that many of them were undocumented foreigners who were not eligible to join the union. The foreign workers filed a lawsuit against the regional labor office. The court ruled that rejecting the union establishment registration based on the fact that the requested documents were not completed was not permissible. Furthermore, the court said that although the individuals attempting to establish the labor union were undocumented foreign workers, this should not be the reason for rejection. In other words, the court ruled that even though a foreign national is residing in South Korea illegally, they should not be deprived of the rights guaranteed by the Constitution. But this didn't mean that foreign nationals residing illegally in South Korea have the same rights as Korean citizens. Examining this case in detail, this means that even though a worker is an undocumented resident, their rights as a laborer should be guaranteed, but it doesn't imply automatically granting legal residency status to undocumented residents. Therefore, they may still be subject to enforcement and deportation. This case highlights the importance of recognizing fundamental human rights and human dignity, even if they may involve a certain degree of illegality in appearance.